In 2001, I represented a young man named Jose Navarro, who was not a citizen of the United States and who was arrested on drug charges in Waukesha County. Though he was read and understood his right to remain silent and his right to counsel and his other rights under Miranda by the police officials who interrogated him, he was never advised by them that he had a right to communicate with the Mexican consulate in Chicago. During the interrogation, he made incriminating statements against himself. In June of that year, I spoke with the Legal Affairs and Human Rights Office of the Mexican Consulate in Chicago. They told me that had Jose been advised that he had a right to communicate with them, and had he contacted them before being interrogated, they most definitely would have advised him not to make any statements at all. Article 6, Section 2 of the United States Constitution makes a treaty signed by the United States the law of the land upon ratification. I knew back when I was working in the city of New Orleans as the mayor's deputy director of international relations and trade development that the United States was party to a treaty that touched on the rights of non-U.S. citizens to communicate with their consulates in this country if they are arrested. The treaty is called the Vienna Convention. It's a 79-article multilateral treaty signed by more than 100 nations, including the United States and Mexico. It was drafted in 1963, and it governs the rights and functions of consular officials and the privileges and immunities associated with their positions. I ended up filing a motion with the judge to suppress the statement that Jose made to the police on the grounds that they violated his right to consular assistance pursuant to Article 36 of the Vienna Convention. The reason I filed a suppression motion was because certain sections of the treaty state that its protections, quote, shall be exercised in conformity with the laws and regulations of the receiving state, subject to the proviso, however, that the said laws and regulations must enable full effect to be given to the purposes for which the rights accorded under this article are intended. Well, how do we enforce police misconduct in this country, especially when it comes to failing to advise people of their rights when they're arrested? We suppress evidence. It's called the exclusionary rule, and that's what our legal system has come up with. The courts came up with that a long time ago. In fact, it's nothing new. And absent any specific statutory remedies for enforcing people's rights, that's what we do. It's that simple. Well, the long and the short of it is that the trial judge agreed that the treaty confers a right, more or less, but he denied the motion, saying that we really don't have any way in our system of enforcing it, despite the fact that there's been the existence of the exclusionary rule for forever. The case got appealed to the District 2 Court of Appeals, and they agreed with the judge. Nice. So great. If you're a foreign national and you're arrested in the state of Wisconsin, even though we recognize that you have a right to communicate and consult with your nearest consulate, we're not going to enforce that right. Good luck to any Americans who go down to Mexico now and get arrested down there and want to talk to their consular officials. What's going to compel them to enforce their end of the treaty? Certainly not our actions. We're not leading by example with respect to this particular issue, unfortunately.